So the Trammel case raises the question of what exactly is the marital privilege. And this we need to note at the very outset that there is a difference between the marital privilege and the privilege from marital communications, which Trammel discusses but doesn't actually involve. So if both spouses have communications that are private, that are just between the two of them, there's a case called Blau versus the United States from the 1950s that still continues to protect those communications. But what about things that the one spouse knows about the other, or information that one spouse may independently learn that would harm, her husband or his wife? Can the prosecution call the spouse to the stand and have the spouse testify against the other spouse? Or can one spouse agree to testify? So Trammell then re-examines this marital privilege, which is different than the privilege for marital communications. So if it's in the house, no one else is there between the two spouses, that's still protected. Each spouse is the holder of that privilege. That if one person doesn't want to talk, that person doesn't have to talk. If one person wants to keep the other person from talking in court, that can be done as well. But what about, this is the question of things that one spouse knows about the other that doesn't involve marital communications, just information that one spouse knows that would be harmful to the other. The old rule was that one spouse could never testify against the other. And when the court lays out the history on this, it's pretty clear which way they're going to go. The court begins by saying, look, this product or this rule is the product of medieval origin. Whenever they say the word medieval, or even worse, Byzantine, then the doctrine is likely to fall. The word Byzantine has come to have a very negative connotation to it. Actually, the Byzantine Empire was the eastern half of the Roman Empire. It's a very, very fascinating history, and it's really quite an interesting place to study. Much like the word Epicurean has come to mean something very different than what it originally meant. Epicurus was someone who believed in moderation, and Epicurean now means someone who wants to gorge themselves. But anyway, the court says, look, the notion of a marital privilege, that one spouse can never testify against another, is of medieval origin. It came from the time in which the defendant was not allowed to testify ever on his own behalf, which is itself strange. But then also the idea that a wife had no independent legal existence. So she was essentially, in the eyes of the law, one and the same with her husband. So if her husband couldn't testify, neither could she. When the court offers that particular history for the marital privilege, it's destined to fail. And then they say, well, what's the modern justification for it? Well, the modern justification, the court says, is that this rule would promote marital harmony. Well, the court says, well, look, if we're talking about someone who wants to testify against the other person, then the marriage is not really in that great a shape to begin with. And the actual testimony itself won't change the fact what's causing the problem is not the testimony. What's causing the problem is the underlying fact that makes one spouse want to testify against the other. So the court says, look, here's what we're going to do with this privilege. We're going to recognize that there is some virtue to not being able to compel one spouse to testify against the other. That if the government could drive a wedge between spouses by requiring one to testify against the other, that might disrupt the family a bit. But if one spouse already wants to testify against the other, well, the wedge is already there. So the court says all we're going to do with this, rather than having both parties be the holders of the privilege, both parties being able to refuse to testify, what we're going to say is now if one party wishes to testify, then that party can do so. that we won't allow one spouse to prevent the other from testifying about things that are unrelated to marital communication. So, like, you know, if the wife sees the husband rob a bank, that's not a marital communication. If the husband comes home and says to his wife, "I robbed a bank today," that is a marital communication. That's still protected. But can the wife or the husband? You don't find many female bank robbers, but it could go either way. But we'll do it the standard historically, statistically more likely way. If the wife sees the husband rob a bank, could she be required to testify against her husband? No, she couldn't be required to do so. But if she wishes to, under the Trammel rule, she can. Now, there's a certain amount of irony to this because the court says, well, the notion here is that if you could compel someone to do it, that might drive a wedge. Think about, though, why Mrs. Trammel was willing to testify against her husband. She was offered a plea deal. So you can't compel her. You can't just serve a subpoena on her and make her come in and testify against her husband. But you can say to her, and this is sort of the back door to the splitting of the family, you can say to her, look, your husband's going to jail for 20 years. We're going to seek to prosecute you for the same offense unless you testify against him, and then we'll give you immunity. So you can still do those things, or the prosecution can still do those things that would have been the equivalent of compelling, the family to turn on itself. You just have to do it indirectly. You have to make an offer. You have to pay for it if you're the government. So there is a certain amount of rejection of the idea of the concern that it's bad to compel one spouse to testify against the other about things that are not marital communications, because you can still do that. That still happened in this case. In effect, at least in criminal cases, this really does eliminate, for all practical purposes, the idea that the marital privilege still exists, because now the government can absolutely put pressure on one spouse to testify against the other about things that are not marital communications. So, just to keep the categories very straight, there is the marital privilege, and then there's the privilege for marital communications. The latter, the privilege for marital communications, survives Trammel. The marital privilege, the idea that one spouse could be prohibited from testifying against the other because the defendant refuses to allow it, that's now gone. But one spouse can refuse to testify against the other spouse. But if that spouse wants to do it, even if it's because a deal has been offered for the testimony, then, as in this case, Mrs. Trammel can testify if she so chooses, consistent with what remains of the marital privilege. The privilege for marital communications absolutely remains intact.